SJC-11753, Commonwealth v. George Sallop.
Thank you.
Good morning.
Good morning, Chief Justice Gantz. Sorry, I'm a little hoarse. And honorable justices, Mr. Sallop is appealing the increase of his sentence after the CPSL portion of his sentence was vacated many years before. I think it would be helpful for me to review the sentence and the procedure to how he got here. Originally, he pleaded guilty to, two concurrent 10 to 15 year sentences on the rape charges, a 9 to 10 concurrent on the ABDW charges, and a 2 to 3 year concurrent on the open and gross lewdness, and lastly, 2.5 concurrent sentences. What happened afterwards, after he filed a motion to vacate his sentences pursuant to CPSL, he was then given, at his resentencing, which was in 2009, concurrent sentences remained the same on the 10 to 15. The 2 to 3 year sentence had already been served in 2009. That was count 4. And the count 3, which was the 9 to 10 year sentence, he was given 10 years probation on and after, along with the sentence on count 4. The issue here,
Say it again, what he was given on count 3?
Count 3 and count 4 were both 10-year probation on and after, concurrent with each other. On and after the...
On and after 1 and 2?
1 and 2, exactly.
And he already served both the 9 to 10 and the 2 to 3?
He had only served the 2 to 3. The 9 to 10 was completed in 2012, so that was 3 years after the 2009 hearing.
But because it was from and after, he would have completed it by the time he began the probationary sentence.
No,
That's
concurrent.
Right. That's correct. It's concurrent, but he would complete it by the time. It is concurrent with the other probation.
I thought you said it was from and after.
The 9 to 10, the probations are concurrent with each other.
Right.
But on and after, count 1 and 2.
So those are the revised sentences.
Right. Probation
That's correct.
follows his incarceration.
Yes.
It's upon his release from incarceration.
That's right.
With regard to count 2, he still had time left on that sentence when he was resentenced.
He had time left on that sentence, and he had time left on count 3 at the time that he was resentenced.
On count 3 was it?
Count 3, the 9 to 10. He was
That's
sentenced.
count 3 because there were two rapes of a child?
Yes.
Yeah.
So 9 to 10. So how much time had he served on the 9 to 10?
At the time he was resentenced.
When he was resentenced.
He had served roughly 8 years.
Okay, so there were 2 years remaining
9
on
to
the
10.
maximum of that sentence.
That's right, 22 months.
So you would argue that, I suppose under Cumming, if we understand how that would apply here, he could receive on that, at resentencing, a 10-year period of probation, but perhaps the only thing that would be suspended would be the 22 months of time he hadn't yet served.
That's correct. That's our interpretation, that on count 4, he was improperly sentenced at all, that there shouldn't be a sentence on count 4 because it had been served already. So certainly under Cumming, and in the cases following, it's been interpreted the same way, Commonwealth versus Scott in the appeals court in January, in a similar case. So what he would be left with then is on count 3, the 10-year probation, but the period of time under Cumming would be the time between the 2009 sentencing and what was left of that sentence, which was, I think, February of 2011. So it would have been 22 months.
So the probation is okay as to one count, but it's limited in terms of what the consequence would be for a violation of probation.
It is okay in the sense that he could have been resentenced, and it's somewhat questionable whether that length of time is actually okay compared to what he had before in terms of an aggregate sentence.
Well, would it not be the case, or is it the case that it would be, upon a violation, he could serve no more than, assuming you're right, 22 months?
22 months.
Provided provided that would not exceed the 15 years which he already had been imposed, since the earlier was a concurrent sentence.
The 9 to 10 years.
No, I'm referring to the 15. Let's assume
Well,
let's assume he had already served all the 15 on counts 1 and 2.
Yes.
And in year 7 of the probation, he violates it.
Yes.
Could he then receive the 22 months, even though that would now be in excess of his earlier sentence, which was maxed out at 15 years?
I'm not sure that I'm entirely following
Okay.
this
Here-
here,
here's
because
what
you're
I'm saying
saying
is that under
15
the
years.
initial sentence, because it was concurrent, the most he could serve would be 15 years with regard
Right.
to the sentencing scheme.
Yes.
Is it your view that that maximum would apply upon resentencing, that whatever happens, he could serve under the resentencing scheme, no more than 15 years?
No more than 15 years total.
Total,
Including what he had already served. Is that what? Okay, so
Yes.
that was the part that I wasn't understanding. So yes, that's correct. He cannot serve more than what he would have served already.
So if he so I think the question is, if he violates parole after he had, probation, after he has completed the 10 to 15, because the 10 years is still running,
Yes.
he couldn't do those 22 months, right?
Well, technically,
that?
if he's put on probation after he's completed the incarcerated portion of his sentence, wouldn't he then be on the probation would only run for 10 years, regardless, and then if he violates, then he will be responsible for 22 months.
Yeah,
time.
and you would say that, right, because I think what you're saying is that if count 3 was redone properly,
Yes.
then it would have, in a sense, well, that's the question, could it increase the incarcerated time beyond 15 years?
It couldn't increase
Well, it
that
would
time.
if you
Well, it
violated
shouldn't
the
increase
parole.
it because under Cumming, the second portion of Cumming, of course, refers to sort of expanding or maybe distinguishing from Leggett and the cases before that the aggregate sentence can't increase. And so that's the second part of the question, right?
But
Yeah,
that's the question I think we're trying to get
Right.
to, is that,
Right.
let's assume, under this sentence, he has
Yes.
10 years probation. Let's assume he gets no parole. So he's finished his 15 years.
Yes.
And in year 8, he's still on probation, because that's a 10 years, and then that'll go beyond the 15 years, correct?
Yes.
So on year 8, he violates probation.
Yes.
Is it your view that he could still get 22 months so that he'd be serving 15 years plus this additional 22 months? Or is it your view that having served the 15 years, he cannot get any time beyond the 15 years?
Well, that's really the question here. And in my view, he shouldn't have to serve additional time. Now, the difficulty with that argument, I understand, is that under what he had before, which was the CPSL, he would have had some additional time hanging over him for a violation, right? But it would have been, even though it's put over the course of a lifetime, a first violation would have been 30 days, a second violation would have been 180 days, and so on. So that I think he would have had to violate 12 times or something like that in order to be
Get
looking at the
22
kind
months?
of time, I think so, or 9 times.
Well, third violation is a year, isn't it?
Yes. Well, right, yeah, my math is a little off, but, so in other words, I'm not sure if I'm answering your question directly.
You are. It's just
Chief Justice Gans.
sort of the implications of coming is, I think, what we're trying to figure out.
Okay.
Who wrote
Okay.
that opinion?
Thank you.
Thank you.
No further questions?
Nope, I think so. I
Thank
think
you.
we're done. Thank you.
May it please the court, my name is Melissa Johnson. I'm an assistant district attorney in Middlesex County.
So how do you answer that question?
The way I would answer that question is to first, what was not discussed actually with my sister is the fact that the CPSL portion of the sentence was eliminated. And we know that since coming, that we have to dial it back and figure out what was the original intent of that, or the intent of the original sentencing judge. And that intent had to have included an extended period of supervised release, and that's what we really need to figure out here, is how do we factor that in? And I can't stand before this court and tell you that there's a magic numerical formula that'll make it all perfect. It's not there, but I can argue to this court what's fair in this situation. And if the question was, first of all, in terms of these probationary sentences, it's our position that given Cummings and Leggett, that because it was a multi-count indictment that had varying degrees of varying lengths of concurrent sentences, that actually any of those were opened to be reconstructed as long as the aggregate of that sentence, that 10 to 15 years, really 15 years, was not tampered with, the bottom line.
So would you, I shouldn't have jumped in, but would you say if it goes back, you can reopen it again? Is that what you're saying?
Yes, it can be reopened
Except
again
that at
as
this
long
point,
as
it's all been served, hasn't it?
He, I believe, wraps up in February of 2016, so he has a little less than a year, according to what we believe was the date he was credited from, which was February 2001.
But with respect to sentences that have been fully served, you can't reopen those, can you?
Yes, yes, Your Honor, it is our position that under Leggett, it's viewed as an aggregate. So if the bottom line is 15, then anything under that those concurrent sentences of different lengths can be reopened. That's what Leggett tells us.
But it seems to me that you have just answered the question. If, in fact, the aggregate cannot involve more than 15 years of incarceration,
Yes.
once he's done his 15 years of incarceration, he cannot be further incarcerated.
Except for that, Your Honor, we have to look back at the original sentencing judge knew when he sentenced him to the 10 to 15 and all of those concurrent sentences, he was going to have the rest of his life to be supervised with all of the mandatory provisions at the time that he would be subject to throughout his life, all of those.
So he would be subject to probation after that 15 years, but not revocation and further sentencing, or he would be subject to both?
I'm sorry, from the original
After
sentence.
After the 15 years.
After the 15
He served
years.
his full 15 years.
Served the
He's got 10
committed.
years from and after probation.
I apologize. I was talking about the original sentence from 2002, Justice Hillman, when he sentenced him to the concurrent committed times, all of varying lengths, the longest being 10 to 15, and then after that, the lifetime parole would kick in. And as my sister had explained, there are varying degrees. First offense, I believe you get it.
That's gone, but that's gone.
That's gone. So now we have to figure out how to replace that in the most fair way.
Without increasing the aggregate sentence, because that would be a double jeopardy problem.
And that aggregate sentence includes committed time, 10 to 15. It also included supervisory time that entailed some exposure to committed time. And so to have that probation running on and after now, the 10-year probations.
So what is the amount of committed time that you say should be involved with that probationary period?
Well, Your Honor, it is our position that those committed time should reflect the indictment of which the probation is on. So
And not the aggregate that he could have been subjected to under CPSL?
Yes, Your Honor. It's our position in terms of a straightforward rule here. For example, the ABDW, count 3, assault with a I'm sorry, I'm abbreviating these. ABDW is a 10-year max. We have the open and gross, I believe that's a 3-year max, and that's his exposure. And I know that you're looking at me thinking, wow, that's a lot of exposure. That may have been.
Why is that available?
Because that's what he has probation on, counts 3 and 4.
But now,
But 3 was the 9 to 10, no?
It was a 9 to 10, but in terms of if he were to have been put on probation for that offense back in 2002, instead of having committed time, and hear me out, Your Honor, instead of having committed time, that's what his exposure would have been. And we're trying to put this in the same place as he would have been. And I think we have to be honest with ourselves in terms of if CPSL was not on the table in 2002, if Justice Hillman, it didn't exist, he didn't know what to do with this particular defendant, the sentence that he received in 2009 by Justice Kottmeyer, it would have been a gift given what he did to that little girl, because here he is at the lowest end of those sentencing guidelines. We had asked for 35 to 40. He got a 10 to 15. Defendant had asked for 10, the lowest end of those guidelines. And the reason being, and this is, I would urge Your Honors to look at the original transcript, and also just in terms of common sense, is because Justice Hillman knew when he got out, he was going to be supervised for the rest of his life.
Let me ask you this. If we accept what you are proposing, we have to change Cummings, right?
Yes, Your Honor.
Leggett and Cummings can't be read consistently together, right?
In terms of the exposure, Leggett didn't talk as much about the exposure if a probation sentence is converted. Cummings addressed that more. So with all due respect, yes, we would have to rethink the formulation in Cummings, and I will just point out that the court did say in the peculiar circumstances of that case, and so for perhaps
that wasn't a rhetorical question. I'm really trying to figure out where you are.
So
And the reason-
your position is that that it's perfectly appropriate to give him the 10 years. You say on both counts 3 and 4, but
under Leggett.
Okay, and that if in year 8 or 9, after having served his full 15 years, which is probably the most likely scenario, he then violates probation.
Yes.
The judge could impose an additional 9 to 10 for the violation of probation.
Anywhere, if the probation is, for example, on the ABD&W count,
Right.
and the exposure on that count is a maximum of 10 years, then that is what the judge in his discretion can do. And the reason being, I realize that seems like a lot of exposure.
Result would be that he could serve 25 years under the resentence.
And he could have done that under CPSL if he had violated over and over again for the rest of your life. Again, it's not perfect. However, if you're talking about exposure here with probation, number one, it's within the discretion of the judge. Number two, it's one and done. He violates it, he's sentenced, he's done. With CPSL, he's got his entire life to violate. And over again, those year sentences are going to accumulate to the point where now he's got more exposure than he did if he had been put on probation. And I will point out that if we go back and like I said, look at that original sentence, and the judge knew he was subject to CPSL, though that committed time would have been so much longer had that not have been available to the judge at that time. So again,
except that another factor, anyway, is that at least when on CPCSL, if he violated probation, the first whack is what, 6 months?
Yeah.
And whereas here, the first whack is 9 to 10 years.
it could be anywhere up to 10 years. It
30
could be,
days
and
is
that's
the first
within
one.
the discretion of the judge. He could do a number of things. He could extend probation. He could do a number of things. With CPSL, it's mandatory, assuming that the legislature figures out a way to get judges.
He has, how much time does he have left on the 10 to 15 right now?
I would say less than a year, Your Honors. And if I could just point something out about the Cummings formulation that was pointed out in my colleague's brief, the issue there is that when you're trying to figure out that exposure date, and this may be a strong word, but when you're talking about the resentencing date as a start position, that's a date that could be somehow manipulated by the parties. It's not fixed, it's not uniform, it's not straightforward. It's sometimes just by the vagaries of how busy the court is that year that someone gets a particular resentencing date. So we're looking for something that's more straightforward. We're looking for something that really reflects what the original sentencing judge intended when they knew they had that lifetime parole to rely on for extended supervision.
Because the problem is, we don't know what Judge Hillman intended. How are we supposed to know what he intended?
We know that, Your Honor, from reading his transcript where he discusses conditions of probation, and then the party said, well, no, he's on lifetime parole, and the judge said, you know, okay.
So is your view that each time this happens, we have to attempt to ascertain what the judge would have done had there been no CPSL?
Yes, Your Honor, and that's what Cummings tells us, is that we have to compensate for that extended period of supervised release. These are not shoplifters. These are repeat sex offenders. We have to figure out how to compensate for that time, because the original sentencing judge always had that in their mind when they decided, how long am I going to put this guy in jail? Am I going to run these sentences concurrent or consecutive? I know that when he gets out, he will be supervised, and that gives me some feeling of, well, perhaps I will lessen the sentence if that, or the committed time, if that's the case. That's common sense, Your Honor. It really is. And then plus, with reading the transcript in this case, you can see these were the things that were going through Justice Hillman's mind.
Do you know how old Sallop is?
He is, I would say, in his late 30s at this point, Your Honor. If the court would like me to address the Scott case that came down, and I can do that.
I think your time is up.
Okay, thank you very much.
Thank
Thank
you.
you.